Welcome to this deep dive. We're using educational materials made available by the University of London and just want to stress this is purely for educational purposes.
Absolutely. And this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
And, from both of us, seriously, good luck to all of you getting ready for your exams.
Yes, best of luck.
Okay, so today we're diving into a really big one. The free movement of goods in the EU, a cornerstone, really.
Definitely. Our aim today is to help you get to grips with the fundamental principles, pulling directly from those University of London materials. We'll be flagging the key concepts, the big cases, trying to make it all stick for your studies.
Sounds good. So, free movement of goods. It goes way back. Treaty of Rome, right. And then the Single European Act, that really pushed the internal market idea forward.
Exactly. And, well, the EU basically used two main approaches to build this single market. You can think of it like negative integration.
That's tearing down barriers, tariffs, checks, that sort of thing.
Precisely. Removing obstacles. And then there's positive integration.
Which is more about building common rules, harmonizing standards across countries.
You got it. Creating that level playing field through common rules.
And these barriers, it helps to split them, doesn't it? You've got the money ones.
Right. Monetary or tariff barriers.
Right.
Things that cost directly.
And then everything else, the non-monetary hurdles.
Yeah. Rules, regulations, delays, stuff that makes trade harder without being a direct charge at the border.
Okay, so the TFEU, the Treaty on the Functioning of the European Union, you'll see that abbreviation. That's our key legal text. It lists the main obstacles we need to focus on.
Exactly. You've got customs duties and these things called charges having equivalent effect, CEEs. That's Articles 28 and 30.
Okay, CEs.
Then Article 110 deals with discriminatory internal taxes.
Right, taxes within a country.
Then Articles 34 and 35 cover quantitative restrictions, QRs and measures, having equivalent effect to quantitative restrictions, MEQRs.
QRs and MEQRs. Those sound important.
They really are.
Yeah.
And finally, Article 37 covers state monopolies of a commercial nature. We won't focus as much on that today, but it's part of the picture.
Got it. But before we dig into those barriers, maybe we should clarify what exactly counts as goods here. Seems basic, but I bet there's a legal definition.
There is, and it's a crucial starting point. The court nailed this down in Commission v. Italy. Art treasures, a really key case.
Art treasures, okay.
They said goods are basically products that can be valued in money and can form the basis of commercial transactions.
So if you can put a price on it and trade it, it's goods. Makes sense. Remember that case name, Commission v. Italy.
Art treasures. Definite one to remember.
And these rules, they're mainly about trade between EU countries, but didn't you say sometimes they can apply even within one country?
That's a great point. Yes, primarily it's about interstate trade. But the court has said, look, even a purely internal situation might get caught if it could potentially affect trade between member states.
Ah, okay. Any examples?
The Jersey Produce Marketing Organization, LTD v. States of Jersey case, is a good one. It involved rules about exporting Jersey potatoes to the UK.
So even though Jersey to UK might seem internal in some ways, it had that potential cross-border trade link.
Exactly. It showed that if there's a potential knock-on effect on intra-EU trade, these rules can bite, even in what looks like a domestic setting. So keep Jersey Produce Marketing Organization in mind for that wider scope.
Okay. So we know what goods are. We know the scope can be broad. Let's talk about the foundation, the customs union, Article 28.
Yes. Article 28 TFEU establishes the customs union. And this is important, and it's not just a free trade area where countries ditch tariffs between themselves.
It's more than that.
Oh, yes. The customs union means, first, no customs duties and no CEEs between member states. That's Article 30.
Right.
But second, and this is key, it means they all apply a common customs tariff to goods coming in from outside the EU. A single external border policy for trade.
Ah, I see. Unified inside and unified outside. And Article 30, the bit banning duties and CEEs between states. That's directly effective, isn't it? People can actually use it in court.
Absolutely fundamental. Thanks to the landmark case Van Gendon Loos, that ruling established that individuals and companies can rely directly on certain EU law provisions, like Article 30, in their national courts.
Van Gendon Loos, a must-know case for direct effect.
Definitely. It's what gives these rules real teeth on the ground.
Okay, let's zoom in on those tariff barriers then.
Yeah.
Articles 28 and 30, and especially these CE charges having equivalent effect. What is a CEE exactly?
The court gave us a very broad definition, developed over time. A really crucial case here is Commission v. Italy, statistical levy.
Statistical levy, what did that say?
It basically said any financial charge, however small, that a member state slaps on goods just because they cross an internal EU border is a CEE, and therefore illegal under Article 30.
Any charge, even if it's tiny, like for collecting statistics?
Even then. That's exactly what the statistical levy case was about. A small charge for trade stats, still a CEE.
Wow, that's strict.
It is. The court focuses on the effect of the charge, not why the member state imposed it. Does it make imported goods even slightly more expensive or difficult to trade just because they crossed a border? If yes, it's a CEE.
So the key question to ask yourself for the exam:
Is this charge payable because the goods crossed a frontier within the EU? If yes, it's almost certainly a prohibited CEE. Remember that test.
Okay, crystal clear test. And does this ban on CEEs only cover goods originally from the EU? What about goods from, say, the US or China?
Good question. No, the court confirmed in Diminatory Biters v. Indiamex that the CEE prohibition also applies to goods imported directly from third countries once they are inside the EU's customs territory.
Diamantorbiters v. Indiamex.
Right. So while the common customs tariff applies when those goods first enter the EU, individual member states can't then add their own extra border charges disguised as something else.
No extra sneaky fees after the official import duty. Makes sense. But weren't there some exceptions allowed under Article 30? Situations where a charge is okay.
Yes, there are 3 narrow recognized exceptions. First, a charge might be allowed if it's genuine payment for a specific administrative service rendered directly to the importer or exporter.
Okay, a service provided to them.
Exactly. It has to be a benefit individually conferred on that specific trader, not just a general benefit to the public interest, like, say, routine health checks. And the charge can't be more than the actual cost of providing that specific service.
In cases for that.
Well, a statistical levy itself discussed this. Finding the levy wasn't for a specific service. Other key ones are W. Katsky, Spie, Bresciani, and Commission v. Belgium. They all reinforce specific benefit, actual costs.
Got it. Specific service, specific benefit, proportional cost. What's the second exception?
The second one is for charges related to inspections that are mandatory under EU law itself or under international agreements that bind the EU.
So if EU law requires an inspection,
then a charge to cover the cost of that specific mandatory inspection can be permissible. Cases like Bauhaus v. Netherlands and Commission v. Federal Republic of Germany established this. Remember Bauhaus for mandatory inspections.
okay, EU or international law mandates it. And the third exception, you mentioned it links to the next topic.
Precisely. The third situation is where a charge isn't really a border levy, but actually falls within the scope of a general system of internal taxation. Think VAT or excise duties that apply systematically to both domestic and imported goods alike.
So it's part of the country's internal tax system.
Then it's not a CEE under Article 30. Instead, it needs to be assessed under Article 110 TFEU, which deals with discriminatory internal taxation. And crucially, these two articles, 30 and 110, are mutually exclusive. A charge is either one or the other, never both.
Right, that's a really important distinction for exams. Okay, let's pivot to Article 110, though. Discriminatory taxation. The goal here is basically fiscal neutrality, stopping tax systems favoring homegrown products.
That's the heart of Article 110. It wants to make sure member states don't use taxes to protect their own goods unfairly. It has 2 parts. Paragraph 1 tackles similar products.
Similar products.
Yes, Article 110.1 says you can't tax imported goods more heavily than similar domestic ones. Then Article 110.2 deals with products that aren't similar but are still in competition. It bans taxes that indirectly protect domestic goods against competing imports.
Okay, similar goods get one rule, competing goods get a slightly different one. And how do we know if something is an internal tax for Article 110?
The Cooperativa Cofruda Salal case helps here. It defined an internal tax as part of a general system of internal dues, applied systematically to categories of products using objective criteria, irrespective of the product's origin. Remember Cooperativa Cofruda for that definition.
Cooperativa Cofruda. Okay, and like Article 30, Article 110 is directly effective too. Individuals can use it.
Yes, absolutely. The Luddick case confirmed that. So if you think you face discriminatory tax contrary to Article 110, you can rely on it directly in your national court. Luddick for direct effect of Article 110.
And it's not just about the tax rate being higher, is it? The way it's collected could be discriminatory too.
Definitely. Commission v. Ireland is the classic example. The tax rate was the same, but Irish producers got more time to pay it.
Ah, a period of grace.
Exactly. That difference in collection method was enough to make it discriminatory under Article 110. So equal treatment applies to the whole system.
Right. Now, this difference between similar products in 110.1 and competing ones in 110.2, The Commission v. UK wine and beer case seems key here.
Crucial case. Commission v. UK, wine and beer. The court said, look, wine and beer aren't similar under 110.1. Different ingredients, different production methods, different characteristics.
Okay, not similar.
But they could be in competition under 110.2. The test is whether they meet the same consumer needs. Can consumers substitute one for the other? That's the competition angle. And consumer habits change. So similar is narrow, competing is potentially broader. Really get your head around wine and beer.
So it's about substitutability for the consumer. What about Commission v. France tobacco? Weren't light and dark tobacco deemed similar there?
They were. In Commission v. France tobacco, the court took a slightly broader view of similarity. They reasoned, well, it's all tobacco, same basic material, same core function for the consumer.
Even if preferences differ slightly.
Even so, they saw them as similar enough for Article 110.1. So you see, it depends on the specific products and how substitutable they are in the eyes of the consumer. Compare tobacco with wine and beer.
Okay, so similar looks at characteristics and core need. Competing looks at market substitution. What about the types of tax discrimination? Direct versus indirect?
Right. Direct discrimination is easy to spot. The tax rule explicitly treats imported goods differently just because they're imported. Har Petroleum is a clear example. A surcharge just on non-Danish goods. It's almost impossible to justify.
Based purely on origin and indirect.
Indirect discrimination is sneakier. The rule looks neutral, it doesn't mention origin, but in practice, it hits imports harder. The classic case is Humblot. France had a much higher car tax for cars with big engines.
And most big engine cars were imported.
Exactly. So while the rule was about engine size, not origin, its effect was to disadvantage imports. That was indirect discrimination.
But didn't another case say if there's no domestic product to protect, it might be okay?
Yes, that's the important point from Danske Bill Importer v. Skatministeriet. If there's actually no similar or competing domestic product being produced, then even a tax that mainly hits imports might not breach Article 110, because there's no protective effect for domestic industry. You usually need to show that protective effect for indirect discrimination. Remember Humblot versus Danske Bill Importer.
So indirect discrimination needs that protective effect. Can it ever be justified?
Very rarely. The court is extremely strict. There are hints in cases like Chemil Pharmaceutische, VDAF, maybe for certain industrial policy goals, and Commission v. France, related to regional policy for overseas territories, that some justifications might exist in exceptional circumstances for overriding public interest reasons.
But it's a high bar.
A very high bar. You'd need compelling evidence that the measure is necessary and proportionate. Justifications are definitely the exception.
And if a state does breach Article 110, what happens? Does it matter if it's paragraph 1 similar or 2 competing?
Yes, the remedy differs. For similar products under the 110, the rule is strict equivalence. You have to tax the import exactly the same as the domestic similar product. Bubige-Trankertrieb illustrates this. The import should get the lowest domestic rate if there's a range.
Strict equality for similar goods.
For competing products under 110.2, the requirement is less strict. You just have to remove the protective effect. The tax difference mustn't shield the domestic product from competition. Commission v. Belgium, spirits versus beer, is an example.
Okay, remove the protection for competing goods. And Article 110, it applies to goods already circulating in the EU. What about direct imports from outside or exports?
Good points. Yes, Cooperativa Cofruta again confirmed it applies to goods in free circulation, but generally not to direct third country imports unless a specific EU agreement with that country says otherwise, see Kupferberg or Texaco.
And exports.
Article 110 isn't primarily about exports, but the Nygaard case suggested it could apply if a country taxed goods destined for export more heavily than the same goods sold domestically. But mostly, 110 is about imports.
Right, that covers taxes really well. Now, the other big category of barriers, non-tariff ones. Articles 34 and 35, quantitative restrictions, QRs, and measures having equivalent effect, MEQRs. This is where it gets really interesting, maybe a bit complex.
It can seem that way, yes. So Articles 34, imports, and 35, exports, ban QRs and MEQRs. QRs are the straightforward ones, actual limits on quantity. Quotas, basically.
Like you can only import 10,000 tons of this.
Exactly, or even a total ban. The court said in Établissement des Frères, the Spanish bulk wine case, that a ban is just a quota of 0. So any numerical limit or outright ban is a QR.
Simple enough, but MEQRs, measures having equivalent effect, the treaty doesn't define them, does it?
No, it doesn't. Our understanding comes entirely from the Court of Justice. initially influenced by an old directive, 7050. That directive distinguished between distinctly applicable measures.
Those are the discriminatory ones, only applying to imports.
Right, they make importing harder or costlier than selling domestic goods, and indistinctly applicable measures.
Which apply to everyone, domestic and imported.
Yes, they look neutral on paper, applying to all goods, but they still restrict trade more than is naturally necessary. Getting this distinction is vital.
And for Article 34 on imports to apply, it has to be a state measure, right? Not just private companies.
Yeah. Generally, yes. It needs to be attributable to the state or a state-backed body. Think Commission v. Ireland, by Irish, or the Apple and Pear Development Council case.
By Irish was state-sponsored promotion.
Exactly. But, importantly, state inaction can also be a breach. If a member state fails to stop, say, private activists constantly blocking imports, that failure itself can breach Article 34. The Commission v. France Angry Farmers case showed this. The state has to ensure free movement.
So the state can't just turn a blind eye. Okay, now the big MEQR definition. Dassenville. Everyone quotes Dassenville.
Yes, Dassenville laid down the classic, incredibly broad definition. And MEQR is all trading rules enacted by member states which are capable of hindering, directly or indirectly, actually or potentially, intra-community trade.
Capable of hindering, potentially, wow.
Exactly. You don't need to prove imports actually dropped. If the rule could hinder trade, even indirectly, it's caught. By Irish again, potential effect was enough. Remember that Dassenville formula. Capable, hindering, directly, indirectly, actually, potentially.
A very wide net. And then came Cassis de Dijon. That blew the doors open even wider, didn't it? Bringing indistinctly applicable rules into Article 34.
Cassis de Dijon was huge, absolutely pivotal. It confirmed that even rules applying equally to domestic and imported goods could be MEQRs if they created a dual burden.
Dual burden, meaning the importer has to follow rules from home and the destination country.
Precisely. The product might be fine in member state A where it's made, but then member state B has different rules, creating an extra hurdle. Cassis said this dual burden could breach Article 34.
And it also gave us mutual recognition.
Yes. The flip side, the principle of mutual recognition. If a product is lawfully made and marketed in one member state, it should, in principle, be allowed onto the market in another member state without facing extra barriers. Huge for the single market.
But Cassis also created an escape hatch, mandatory requirements.
Exactly. It said, okay, these indistinctly applicable rules can be justified if they're necessary to satisfy mandatory requirements, basically, important public interest objectives, but only if there aren't harmonized EU rules, and the national rule is proportionate.
What were the original Cassis ones?
The court mentioned things like consumer protection, effective fiscal supervision, public health, and the fairness of commercial transactions. The list isn't closed, though. It's grown over time.
And proportionality is key here, like in the Walter Rau case with the cube-shaped margarine.
Perfect example, Walter Rau. Germany required margarine in cubes, supposedly for consumer protection. The court said, hang on, labeling would achieve that just as well and be less restrictive on trade. The measure has to be necessary and the least restrictive option.
And just to be clear, if it's about public health, you'd normally use Article 36 first, not these Cassis mandatory requirements.
Correct. Article 36 TFEU lists specific grounds like public health, morality, security. As APISA v. DSSE, Erganesa confirmed, Article 36 is the primary justification route for those areas. But other things, like environmental protection, have been accepted as mandatory requirements under the Cassis logic. Think Commission v. Austria and the lorry ban.
And other examples of mandatory requirements.
We've seen protecting national culture, Cinethek film release windows, sociocultural reasons, Torfane Sunday trading, press diversity, familiar press prize competitions in magazines, even fundamental rights. Schmidberger allowing a protest that blocked a road.
Okay, so a key difference to remember for exams. Article 36 can justify both discriminatory, distinctly applicable, and non-discriminatory, indistinctly applicable measures. But Cassis mandatory requirements can generally only justify indistinctly applicable ones.
Exactly right. The Commission v. Ireland souvenirs case nails this. Ireland's rule requiring imported souvenirs to say foreign was distinctly applicable. It only targeted imports.
So they couldn't use a Cassis argument like consumer protection.
Nope. They had to try and fit it under Article 36 and failed. It shows the limit of the Cassis justifications.
What about the other way around Article 35, restrictions on exports? Is that interpreted as broadly as Article 34 on imports? Does Dassenville apply fully?
Generally, no. Article 35 has usually been read more narrowly. The classic case, P.B. Grunwald, said Article 35 mainly catches measures that discriminate against exports, treating them worse than goods sold domestically.
So usually about discrimination.
Usually. But remember the Jersey Produce Marketing Organization case. That suggested if a rule, even a domestic one, could potentially hinder the re-export of goods to another member state, Article 35 might be relevant. But the focus is typically narrower than for Article 34.
Right. Now, the Keck and Mythwar case, this seems like a big attempt by the court to rein in the massive scope of Article 34 after Dassville and Cassie's. What did Keck do?
Keck was definitely a landmark attempt at clarification in the early 90s. The court basically drew a line and said Article 34 does not apply to certain selling arrangements.
Selling arrangements, like rules about how you sell stuff.
Exactly. Rules concerning where, when, by whom, or how goods are sold. Think shop opening hours, advertising restrictions, who can sell certain goods. Keck said these fall outside Article 34 if two conditions are met.
Okay, what are the conditions?
1. The rule must apply to all relevant traders operating within the national territory. 2. It must affect the marketing of domestic and imported products in the same manner, both in law and in fact.
Apply to everyone, affect everyone equally in law and fact. So it created a distinction.
Yes. Between these selling arrangements, outside Article 34 if non-discriminatory, and product requirements, still inside Article 34. Product requirements are rules about the goods themselves, composition, size, packaging, labeling.
So a good rule of thumb is, does the importer have to physically change the product or its packaging to sell it in that country?
That's a really useful way to think about it. If, yes, physical change needed, it's probably a product requirement, and CASIS, mutual recognition mandatory requirements, applies. If no, just a rule about how or where it's sold, it might be a selling arrangement, potentially outside Article 34 altogether under Keck.
Examples of selling arrangements found outside Article 34.
Things like restrictions on pharmacist advertising, Hunermund, Sunday trading rules, Puto Casa, bans on TV advertising for certain sectors, Leclerc-Siplek. The court said these applied equally and were selling arrangements. Remember those as Keck examples.
But sometimes a rule about marketing can affect the product itself, right? Bringing it back into Article 34, like Clinique or Mars.
Absolutely. The line isn't always bright. In Clinique, the court said restricting the brand name itself wasn't just about selling, it affected the product's identity. In Mars, those plus 10% flashes printed on the wrapper were seen as part of the product's presentation, not just a selling method.
And Familia Press, prize competitions in magazines.
Also deemed not a selling arrangement, it related to the content of the product. So even if it relates to sales promotion, if it affects the product's intrinsic characteristics or presentation, Keck might not take it outside Article 34.
So Keck tried to simplify, but it wasn't perfect. And haven't later cases kind of evolved beyond Keck, moving towards more of a market access idea?
You're spot on. Keck's distinction, especially the equal effect in fact part, proved difficult. Cases started highlighting that even neutral-looking selling arrangements could hit imports harder.
Like the Gourmet International Products case, the alcohol advertising ban.
Exactly. Gourmet is key. A ban on advertising alcohol looks like a classic selling arrangement applied equally. But the court said, hang on, imported brands rely much more heavily on advertising to break into a new market than established domestic ones.
So the factual impact wasn't equal.
Precisely. It hindered market access for imports more severely. So the court said, even though it looks like a selling arrangement, its disproportionate impact on market access brings it back within Article 34. T.K. Heimdienst, doorstep selling rules, pointed in a similar direction.
And more recent cases like the Italian mopeds one or Mickelson with the jet skis,
Yeah.
they seem to focus even more on whether market access is hindered, especially for rules about using products.
Yes, there's definitely been a shift. Commission v. Italy, mopeds, and Mickelson, jet skis, suggest that even rules on product use, not selling, not product characteristics, can fall under Article 34 if they substantially restrict market access for imported goods. If you can't easily use the imported product, you're less likely to buy it.
So the focus is broadening again, looking at the overall effect on access.
It appears so. Cases like Scottish Whisky Association, minimum pricing, and DPV, online pharmacies, also seem to prioritize whether the national measure significantly impedes access for goods from other member states, rather than getting bogged down in the strict Keck categories. It's more about the practical barrier to entry.
So CAC, it's still there. It hasn't been formally overruled.
No, not formally overruled. We still see it mentioned, like in Visnapu or Colruyt. The basic distinction can still be useful.
But its importance seems reduced. The main question now is more like, Does this rule, whatever we call it, genuinely restrict market access for imports?
That seems to be the direction of travel. The market access test is becoming the more dominant lens through which the court views potential MEQRs under Article 34.
Okay, that's a huge amount of ground covered, but super helpful, especially laying out the evolution. So, quick recap for exam preparation.
Right. Key things. Understand the ban on tariff barriers, customs duties, and CEEs, Arts 2830, and discriminatory tax, Art 110. Know the difference.
And the ban on non-tariff barriers, QRs and MEQRs, Arts 34, 35.
Crucially, know the justifications. Article 36 for specific grounds can justify discrimination, and the CASI's mandatory requirements for indistinctly applicable rules must be proportionate.
Remember Dasonville's broad MEQR definition.
And how CAS has brought in indistinctly applicable rules and mutual recognition.
Then Keck's attempt to distinguish product rules from selling arrangements.
And the subsequent shift towards the market access tests seen in cases like Gourmet, Mopeds, Mickelson. Be familiar with those key case names and what they stand for.
Definitely review those treaty articles and the cases we've walked through. Knowing the difference between distinctly and indistinctly applicable rules and which justifications apply is vital.
Absolutely. Being able to recall Dasonville, Cassis, Keck, statistical levy, wine and beer, and the others, and the principle each represents, that's gold dust for the exam.
Okay, and one final thought to leave you with as you revise. Given this move towards an access to market principle, how do you think courts might evaluate future national regulations, especially ones that don't fit neatly into the old boxes? It's a live issue.
A very good question to ponder. It suggests the focus will remain on the practical effect of rules on trade, regardless of their form.
Food for thought. Again, very best of luck with the exams.